Hello friends, welcome once again to this video series on law of evidence. And as we were discussing section 3 of Indian Evidence Act, which is an interpretation clause where certain meanings of certain expressions are provided, and those words are to be interpreted in light of those meaning until and unless the context otherwise required. We have already seen this. Today, this would be the last section or last session on the section 3 of Indian Evidence Act. And in this session, we will be discussing proved, disproved, and not proved. These three terms, along with the definition of the term India that is given in the Indian Evidence Act 1872. Before proceeding any further, let us have a brief overview on what all we are going to learn in this session. First, we will see the definition of these three terms, that is, what is meant by proved, what is meant by disproved, and what is meant by not proved. Thereafter, we will see one most important distinction which is asked many a times in interview also, that is difference between proof of a fact and evidence of a fact. Normally, in layman's language, people take these two terms, proof of a fact and evidence of a fact, as synonymous. But legally and technically, they two are different. And in this session, we will see the basic difference between them. Thereafter, we will analyze the definition, that is of proved, disproved, and not proved, and we will see the 3P concept involved in the probative force of evidence. Thereafter, we will also see the standard or degree of proof in respect of civil proceeding and criminal proceeding. Friends, this section 3 actually states the standard or degree of proof required in any matter. Now, this is the only section that deals with it. And we will also study this degree of proof which is required with respect to civil proceedings and with respect to the criminal proceedings. Let us start with the session. And first of all, we will analyze the three terms which are given as it is in the Bare Act. The word proved, it is written, a fact is said to be proved when after considering the matters before it. Mind you, friends, it is the matters before it, not the word evidence before it. The court either believes it to exist or considers its existence so probable that a prudent man, under the circumstances of particular case, to act upon the supposition that it exists. That is, proved means that something which creates a tendency of persuasion in the mind of a prudent person that most probably that thing exists. Similarly, disproved has been defined as a fact is said to be disapproved when, after considering the matter before it, mind you, friends, here also after considering the matter before it, it's not after considering the evidence. So, broader term has been used. The court either believes it does not exist or considers its non existence so probable that a prudent man ought, under the circumstances of particular case, to act upon the supposition that it does not exist. So, disproved means that anything, after consideration, produces a tendency in mind that that particular thing does not exist. Now, not proved means a thing which is neither proved nor disproved. A fact is said to be not proved when it is neither proved nor disproved. That is, its existence or non existence both are not confirmed. That is not proved. My new friends, this term not proved has been asked in preliminary examination many a times. Now, let us see the difference between proof of a fact and evidence of a fact. Friends, as in the overview part, we have said that these two terms in layman language, that is proof and evidence, are taken to be synonymous. But legally, technically, the two are different. And the basic difference is are these two. The first difference is that proof is the effect or the end result of the evidence, and evidence is one of the means of proof. So, proof is the end result, while evidence is the means through which something is proved. So, it is a means, and this means led to this end result. And second thing is that this evidence is only one of the means to prove a thing. There are other ways also through which certain things are proved. That is, proof is effected by means like evidence, and other than evidence, like presumptions, judicial notices, inspections, admissions. These are the things through which a matter can be proved other than the by means of evidence. For example, a fact admitted need not be proved. No evidence should be given. If a fact is admitted, then the court may take it to be proved, and evidence need not be given to prove that thing. Similarly, if there is a matter of which court should take judicial notice, for example, sun rises in the east. Now, this thing is proved because court will take judicial notice of it, because out of common geographic knowledge, it is that the sun rises in the east and sets in the west. No evidence is required particularly to prove this fact because court will take judicial notice of it. So, the term proof of a fact and evidence of fact are not synonymous. Proof is the end result, while evidence is one of the means to prove a thing. At the same time, there are other ways also through which a thing can be proved, and one of them is evidence, others are presumptions, judicial notices, inspections, and admissions. Now, let us proceed further and analyze the definition as such, which is given under section 3, which we have just read. So, first point to be noted is that the term is used very broadly. That is, as I pointed out while reading the Bare Act, that what is written is that a fact is said to be proved when after considering the matter before it, not only the evidence. So matter consists of many things like judicial notices, admissions, presumptions. Apart from the word evidence will certainly come in it. Similarly, disproved, and also it is after considering the matters before it. So not only it is not limited to evidence, rather it is a broad terminology where other things apart from evidence also comes into play. So this is one thing, that it has got a broader definition and a broader term is used. And then one very important thing is that the probative force of an evidence, or the degree or standard of proof that is required, is given under this section, under this clause. And what is that? They require that a prudent man, not a suspicious person, not a person who is not prudent, not a person who is not of normal mental capacity. So they say that a prudent man, then probability That is, there should not be mathematical presumption that 100% we prove that this thing is there. Rather, probability is there, that most probably, most likely it is to be there. And then particular case, the thing is not to be seen in general terms, but in the reference to that particular case, in reference to that particular circumstances. So the standard of proof or the degree of proof that is required to prove a fact, to disprove a fact, or to leave it proved or not proved, then that is not by mathematical precision of 100% proving that yes, that fact exists or does not exist. But what is there is that the 3P, that is, a prudent man should have that probably in reference to that particular case the thing exists in order to make it proved, and does not exist in order to take that the matter is disproved. Now, this was what was laid down in the famous case of Naval Kishore Somani versus Poonam Somani. That what is required is not the mathematical precision to prove or disprove a fact, but what a prudent man under the particular case would probably think of it. Now, moving further, we will go on in another topic, that is standard or degree of proof in respect of civil and criminal proceedings. Now, as we had discussed earlier, that a thing is not to be proved with mathematical precision. What is required to be done is that a probability is to be made that a prudent man under the particular circumstances would agree with it. Now, is this degree of probability same as that of civil, same as in civil and criminal proceedings? Is the degree of probability that is required for a thing to be proved, for a thing to be disproved, same in civil and criminal proceedings? The answer to this is that no. There is a difference of standard or degree of proof or the degree of probability which is to be seen in a civil case and a criminal case. Now, what is that difference in the standard or that difference in the degree of proof? That has been laid down by Best in his book on evidence, and he says that in civil case what is required is preponderance of probability, that is, most probably the thing exists, while in criminal case what is required is proof beyond reasonable doubt, that there should not be any fair doubt with respect to the matter. So in civil case, what is required is preponderance of probability, while in criminal case, a higher standard, higher degree is required, that is proof beyond reasonable doubt. This was also emphasized in the case of Asis Batham versus State of MP. So one difference of the standard or degree of proof with respect to civil and criminal cases, that in civil case what is required is preponderance of probability, while in criminal case what is required is proof beyond reasonable doubt. Now, why this difference of degree or standard of proof is there? Now, that was laid down by the famous code of Farad justice, where he said, it is better that 10 guilty men should escape rather than one innocent should suffer. That is, in criminal proceeding, the idea is that no innocent should suffer. And it can be at the cost that 10 guilty men escapes. And that is why in the criminal proceeding what is required is that proof beyond reasonable doubt, while in civil what is required is preponderance of probabilities. Then Another difference between the civil standard of the degree of proof required in civil and criminal proceeding is that there are two main differences. One is that in criminal case there is presumption of innocence. They all are derived from what Justice Horan said, that let 10 guilty men escape, but not let one innocent man suffer. And what is that? First thing is that presumption of innocence. That an accused, when he is brought before the court, the presumption is not that he is guilty, the presumption is that he is innocent. And this presumption continues till it is proved beyond reasonable doubt that he has committed the crime. Similarly, but that is not the case with the civil proceedings. Similarly, there is another concept of benefit of doubt. That is, if a particular thing, if a particular matter can be interpreted in two different manners. Now, one would go in favor of the accused while another would be against the accused. Then the court has got to give the benefit of doubt to the accused. That is, that hypothesis will be taken which is in favor of the accused. But that is not in case of the civil proceeding. But there is another thing, that it's not that there is hard and fast rule regarding degree of proof or standard of proof in civil and criminal proceeding consistent. For example, what it means is that in all civil proceedings, it is not that the same degree or same standard of proof is required. In within civil suit also, the degree or standard of proof varies from case to case. For example, in a contested case, civil case, balance of probabilities would be required. While in an uncontested case, except for matrimonial case, minimal proof will be required. So within the civil proceedings also, there is not a uniform standard that has been set up, but it would depend upon the case to case. Similarly, would be the case of criminal proceedings. So this was laid down by Justice Denning in famous case of Barter versus B, where he says that no, there is no absolute standard in civil proceeding or criminal proceeding, and there is degree or a standard of proof within the civil proceedings as well as within the criminal proceedings, which would vary from the type or the nature of the case. Now, that's what this point was also emphasized by the court in Rajik Ram versus Jaswant Singh case, where it said that the same evidence which may be sufficient with regard to a fact proved in civil suit, that is, that evidence which would be sufficient to decide a civil suit may not be sufficient, may be considered insufficient for conviction in a criminal action. So there is a difference of degree of proof or a standard of proof that is required in a civil proceeding and that is required in a criminal proceeding. In civil proceeding, what is there is that balance of probabilities, but it would vary within the civil case itself. While in criminal proceeding, it is proof beyond reasonable doubt. So this was all with the term proved, disproved, and not proved. Now the last expression which has been given is expression India, where it says that India means territory of India. Then the term certifying authority, electronic signature, electronic form, electronic record, information, secure electronic record, secure digital signature, subscriber shall have the same meaning as has been given in Information Technology Act 2000. So please remember that they may ask that whether they have been separately defined or whether they have been assigned in the same manner as in the Information Technology Act. And please remember, friends, that they have been assigned the same meaning which is there in the Information Technology Act. Now, this is what is the extent of the Indian Evidence Act, that is whole of India. With this, we come to the end of this session, but before ending it, I would just like to go through what all we have studied, a quick recap of the whole thing. So, in this session, we learned that proved, disproved, and not proved has been given in the section 3, where proved is said that a matter, after considering the matters before it, the court considers it to exist, or a probability is that a prudent man, depending upon the circumstances of particular case, will act on the supposition that it exists. Disproved means that the court considers it to be not in existence, or it does not exist after considering the matters before it, or the probability that a prudent man under particular circumstances would draw is that it does not exist. Not proved means that it is neither proved nor disproved. The difference between proof and evidence is that proof is the end of the evidence and evidence is a means of providing a proof. Then there are other means like presumption, judicial notices, inspection, and admission for proving a fact. Now, the term has been broadly given. The word matter is used, not the word evidence. So, the court, while seeing that the matter is proved or not proved, has to see the whole of the matters put up before it and not only the word evidence. Then, the probative force depends upon what a prudent man under particular circumstances would have the probability of, not a mathematical precision as has been laid down in case of Naval Kishore Somani versus Poonam Somani. Then there is a difference in standard or degree of proof in respect of civil and criminal proceedings, as Best has remarked that in civil proceeding what is required is preponderance of probability, while in criminal case what is required is proof beyond reasonable doubt. And the same has been emphasized in the case of Assis Betham versus State of MP also. The idea behind it was laid down by Justice Horard, where he says that it's better that 10 guilty escapes rather than one innocent suffer. And the two general rules which separates the criminal case from civil case as far as evidence is concerned is that there is presumption of innocence in favor of the accused and there is a benefit of doubt in favor of the accused. Justice Denning in case of Barter versus B has said that there is no absolute either in civil case or in criminal case. However, there is degree of standard or degree of proof within that particular category also. For example, in a civil suit which is contested, what is will be seen is balance of probability, while a civil suit which is uncontested, what will be seen is that minimal of proof. However, matrimonial cases are an exception to it. That was also emphasized in Rajik Ram versus Jaswant Singh's case, where it was said that the same proof which may be or same evidence which may be considered sufficient in civil suit may be considered insufficient for conviction in a criminal action. Now, India means whole of the territory of India, and there are certain electronic terms like certifying authority, electronic signature, electronic forms, electronic records, information. Remember, friends, information also. Secure electronic record, secure digital signature, subscriber, and they have been meaning as given under the Information Technology Act 2000. Thank you so much, friends.